parties involved against a 70-year-old woman. And she was terrified. I said, Dorothy, you've just got to think about what's at stake here. If you don't get this $14,000 judgment against you removed, you're ruined financially. You're just absolutely ruined. Because you'll never pay it off. They'll take any property you have. And it's just a terrible. So what we did is we objected to their answer, and Deborah's going to read the objection. Okay, this is page 1 of the last 2 pages that are attached to that pleading.
Objection. Plaintiff's objection to defendant's unverified motion to dismiss and defendant's unverified response to plaintiff's motion for summary judgment. Report. Defendant's motion to dismiss can be lawfully considered by this court. Defendant's motion to dismiss pleas matters off record. If dismissal motion also tenders for consideration material outside of pleadings, summary judgment procedure must be utilized. Bray v. Thomas Energy Systems. Fact is, material for purposes of motion for summary judgment is proof of that fact would have effect of establishing or refuting one of the essential elements of cause of action. Brown v. Oklahoma State Bank and Trust of Veneta, Oklahoma. Unsupported contentions of material fact are not sufficient on motion for summary judgment, but rather material fact must be supported by affidavits and other testimony and documents that would be admissible in evidence of at trial. Cinco Enterprises versus Benso, Oklahoma. Defendant's response to plaintiff's motion for summary judgment cannot be lawfully considered by this court. Defendant's response to plaintiff's motion for summary judgment contains objectionable hearsay articulated as fact number 1 through fact number 11, and additional material facts not in controversy articulated as Exhibit A through J. Statements of counsel in brief or argument are not facts before this court. Statements of counsel in brief or in argument are not sufficient for a motion to dismiss or for summary judgment. Trimsey v. Pagliaro. Where there are no depositions, admissions, answers to interrogatories, or affidavits in support of motion for summary conclusion, the motion cannot be considered. Oklahoma State Title 12, Chapter 12, Rule 13. Conclusion. Determination by this court that Carl F. Hirsch has not named a fact witness for any of his unverified allegations and has not supported his allegations with affidavits of competent witnesses justly requires that neither oral or written pleadings on behalf of the defendants be part of the record.
Thank you, Deborah. Starting to get real familiar, or somewhat familiar.
So you understand what she was saying is that a lawyer cannot be the lawyer and a witness in the same case. The lawyer has no personal knowledge of the facts of what went on in the case, so he can't get up there and offer evidence. So you always object when the attorney opens his mouth and try to submit evidence in the record. He has to show up with a witness, or he has to come with a signed, sworn affidavit. So, like I said before, like and subscribe. I put the title of this video right there so you can see it. You go type in the title of this video on YouTube and the original video will come up. So it's very important to know what's going on in these secrets that the legal courts do not want you to know about. So make sure you look at this video from beginning to end and understand what these people are trying to tell you. Trinity versus Pacalaro is a 40-year-old case and it's still good on the record.